Okay, the time is 9:07. Mike Lewis and Catherine Hammond is our guest today. And Catherine, as we're going to talk about, Catherine has been on the Extra with Paul Richards many times. And we're going to talk about what happened to Paul because, unfortunately, what you do and what you talk about all ties into this. And, Paul Richards passed away unexpectedly on Sunday. And once funeral arrangements are complete, we have an idea when they're going to be, but we want to make sure the family is settled in on that. We will announce it, and anyone who wants to come, it'll be announced on KRDO News Radio, KRDO News Channel 13, and, of course, online as well. Catherine, it is good to see you again.
It's really good to see you, Mike, and good to be here.
Well, you have a, 22 legal career, 22 years. That's a long time. You're in private practice, and your specialty is helping people take care of wills, estates, things like that. Is that correct?
That's it, exactly. And I started doing that because of the tragedy in my own family when my mother had early onset Alzheimer's. Mm-hmm. But my passion has continued to grow because on a daily basis, I'm working with families who are either planning for when they will pass away, dealing with a disability, or working with families who have just lost a loved one. And so, as I was just saying to you before we started on the air here, it's a little bit of an uncomfortable situation because the topic touches so close to home with Paul's passing this week. And yet I think that we can really honor part of his legacy this morning by talking about the stuff that's uncomfortable. That's why so many people don't have this taken care of, because it's not fun, it's not comfortable.
And I suppose, especially when it happens when, Paul was he was certainly not an old individual, you don't think it's your turn. I mean, you just don't think about it.
We don't think that it's our turn. He was just a few years older than I am. Mm-hmm. And it's a constant reminder of the shortness of our time on earth, mm-hmm. and the importance of really living our legacy. And that's the thing that really strikes me as I think about Paul and getting to know him, especially this year, just through coming in and chatting with him on the radio. The things that really stand out to me are his personal legacy with me. I'll say there are very, very few people in this world who I felt like saw me and appreciated the best in me like Paul did. That is a gift that he gave to me, and I would imagine most people that he spent time with.
Yes, people that he would work with and interview. I got a lot of, we've had a lot of comments, and they said he always made me feel welcomed. He always took interest in me, never had a bad word, some of the coworkers here at KRDO said they never saw him lose his temper, which, is not the easiest thing to do, especially in a high-paced and a high-pressured industry that we are in right here.
It's really remarkable. Mm-hmm. Yeah. And his professional legacy in terms of his impact in the community, his energy and enthusiasm, his real desire to make a difference in the world. Yeah.
Our guest today is Catherine Hammond, and we're going to dig into some very important issues because, as you just said, it's not a matter of if, it's a matter of when. Dave Ramsey talks about this a lot, too. Matter of fact, Dave Ramsey's update this morning, Dave has a report that runs at 6:50 every morning. It's called the Dave Ramsey Reality Check. He talked about having a legacy drawer. And what he meant by that is, he said, show your family that you love them, have a drawer in your home and where your loved ones know it is. And basically, he says, make sure your will is in there, your final instructions, everything your family needs to carry on, maybe passwords for different websites, things like that. And he said, leave it there so if something does happen to you, then the family can reach in that drawer. He calls it a legacy drawer, and they can move on. And he said it's a great way to show your family how much you care about them.
Absolutely. Yeah, I think there are two other types of legacies that we can leave. And one of them is the financial legacy, if there's something that you want to leave behind financially. And then the other one is the whole practical side, the peace of mind, both practically and legally. And that's where estate planning comes in.
Okay. All right. Our guest is Catherine Hammond. These are some of the topics we're going to talk about. 4 types of legacies: the personal, professional, financial, peace of mind, and we'll dig into it. One of the things that I would like to talk to you too, Catherine, is we hear a lot about trust and creating trust, and I'd like to break that down. What does that mean? Because you see a lot of people, they create a trust, and there's a non-revocable trust and trust that can be revoked. Why should someone do a trust, or why shouldn't they do it? What are the pros and cons? So we're going to get a lot of legal education. We're going to class this morning, and our professor is Catherine Hammond on KRDO News Radio, 105.5 FM and 1240 AM. We'll continue in a moment. A little bit later this hour, we'll give you a chance to win a gift certificate to Captain D's Seafood Restaurant. The time is 9:13. We'll get to it with Catherine in just a moment. All right, our guest is Catherine Hammond. Catherine, if folks want to reach out to you after they hear all the great information you're gonna pass along, what's the best way to reach you?
The best way to reach us is by calling our office, 719-520-1474, or you can go online to our website, coloradoestateplan.com.
All right, let's go ahead and break it down. If someone walks into your office and says, you know what, I don't have a will, but, I'm married, I've got kids, what are you going to walk them through? What are you going to help them do? What are you going to help them plan? What do they need to do?
Yeah. First of all, the people walking into our office always come in with some questions about whether they really ought to be there or not. Because a lot of us don't have a lot of stuff in this lifetime. Our bank accounts aren't huge, and we don't have a huge business or other assets that we think really require estate planning. So some people are really intimidated coming into an estate planning attorney's office. We're really there just to chat mostly with really everyday people about your situation, the assets that you own, the specifics of your children and who they are if you have children, or your other beneficiaries if you want to leave things to other people, what it is that you're hoping to accomplish. And that's where it gets a little bit, we go down a little bit of a different road from where most people typically think about estate planning. We need to understand what people are actually trying to accomplish. And so we spend a lot of time in an initial conversation asking about what are your concerns, what are your goals when you pass away? Some people, it's important to make things as easy as possible for their family. Some people are really concerned about making sure that their children don't get the money too soon and blow it on the wrong things. Some people really want to make sure that their son-in-law, who they never really liked, is never going to get his hands on the money that they worked hard for. A lot of people want to keep the government out of their business. A lot of people want to keep the lawyers and judges out of their business. So we have a conversation just about what people's situations and goals are, and then we're able to, once we know specifically what somebody's situation looks like and what they're wanting to accomplish, specifically answer questions that they have, and then make some recommendations. And recommendations would be for what kinds of documents would help you if you become incapacitated, and what kinds of documents would help you when you die, as in a will or a trust.
Okay, and we're going to find out what the difference is and why one should have a will or trust or both, and that's why you are here. I also wanted to bring up one thing. It's my understanding, but I want to make sure that I'm correct in this. I have heard that wills are state-specific. So if you move from one state to another, let's say you're in the military and you just transferred to Colorado, do you want to have a Colorado will? Is that correct?
It is correct that a will is state-specific. Most wills, if they're executed correctly under the laws of the state to which you move, your will would still be completely valid. But there are some states like California, they don't require a notary on a will. So somebody moving from California to Colorado absolutely needs to bring their will into an attorney and have it reviewed and probably execute a new one, because we want everything to be as smooth as possible when you die.
Sure. And again, you've left your family members behind and you want to move on. And like you said, minimize how much the government's going to take, things like that. Well, let's go ahead and then talk about a trust. What is a trust?
A trust is a word that sounds like something that is only for people who are very wealthy. In reality, there are all kinds of different trusts, and some of them are for people who have more wealth. Some of them are just as appropriately used for the everyday person. A trust really just means it's a theoretical box, just an empty theoretical box into which you would put your stuff. So the most common estate planning vehicle is a revocable living trust, and it's just your own personal treasure chest, and you just put your things into there, your house, your bank accounts, your investments, your business interests, things like that. And then it still all belongs to you. You're still completely in control, but it's within your own little treasure chest, so that when something happens to you, either disability or death, instead of the government, the court, having to get involved and give somebody the key to your treasure chest, or having a mess of stuff all around your room, theoretically, it allows you to just hand the key to your personal treasure chest to somebody else, so that they can just take care of things without having to deal with lawyers and judges and probate procedures.
So if you have a trust, then you don't have to probate a will then, or you don't have to go before a court. It's all done.
If it's incorrectly, yes. And that's why most people do a trust, because otherwise, for most people, if you own a piece of real estate, when you die, it's going to go through probate.
Okay. Now, I've heard the term revocable trust and non-revocable, and the non-revocable, to my non-legally trained mind, sounds like I can never change my mind once I do it. Is that true?
That is almost true. An irrevocable trust is much harder to change, and so they're not used as a general estate planning tool like a revocable trust is. Okay. They are more for sometimes they're used for Medicaid planning purposes. If we want to protect some of your hard-earned money from having to go to the nursing home, we can use an irrevocable trust. You have to give up control over your assets in the trust in Colorado. There are also some irrevocable trusts that can be used for liability protection, asset protection. If you're an emergency room doctor and really worried about getting sued, an irrevocable trust is one of the tools that we might look at to try to protect some of your assets if you were sued.
I see. And, Colorado voters very recently passed a right to die in the last election.
Right.
So people can choose to have life-ending medication given to them. But, one of the concerns from the people who were against that issue, because we spoke to them before the election, was, well, what if a family member might be pressuring grandma or aunt and uncle because they know they stand to inherit something, so they just want to speed things along? I don't think that happens in most cases, but it certainly is a possibility. It certainly was a concern of the people who were against the issue. So my question is this. You could set up a trust or your will to say that under no circumstances do I want that given to me. Is that true? And then no one taking care of you could do that? Is that something you can do?
Wow, that's a great question, Mike.
Thank you.
So, yeah, the aid in dying law is a whole big thing that I'm going to be really interested to see how it plays out once it actually comes into effect and we have a chance to live with it for a while. The will and the trust really only deal with your assets. Mm-hmm. They don't deal with your medical decisions. Okay. So that's where medical directives come in.
Okay.
So in Colorado, we have the advanced directives allow us to name somebody who will make medical decisions on our behalf if we can't communicate those. Okay. And of course, you want to choose somebody who you really trust. And then what's commonly known as a living will allows you to communicate some things about end of life. I have not yet seen whether there is going to be an addition into the statutory Colorado form that relates to the aid in dying drugs that will now be permissible. I think it's something that's really important for people to communicate. Sometimes we use another document called 5 Wishes that's like a living will but an expanded version. For people to communicate now, no matter what happens with this law and the way that it plays out, to communicate something about what quality of life means to you. Mm-hmm. and what are the circumstances in which you would want your life prolonged, and what are the circumstances under which you would not want your life prolonged. My mother spent 20 years in a nursing home. She was vegetative for many of those years. It was not a fun existence. And she had a lot of friends early on who said, this makes us believers in what used to be called the Hemlock Society. They didn't want to be kept alive that way. Communicating ahead of time what quality of life means to you. And if you have some specific thoughts in relationship to the new law that we just passed, write those down in your medical directives. And it might be, again, 5 wishes or a living will. But make sure that those are clear and that the person who's going to be making your medical decisions understands your wishes and is named in a valid legal document.
Okay, boy, this gets complicated and deep. That's why Catherine is here. So it's, and I'm getting a great education now too, Catherine, because, you think, well, you put that in the will. No, this is a separate document. These are so many things that we have to think about, and you want to do it while you are lucid. So,
Right.
so you can, make sure your wishes are followed. There are people who are, devout Christians, and I know that talking to them, they under no circumstances would want life-ending drugs given to them prematurely. Mm-hmm. So these are things that you have to think about as we work through this process.
Right.
Okay.
Really sticky.
It is. Wow. We could spend all day in here, I think, with Catherine Hammond, but we still got 2 segments coming up. It is 9:26. You're on KRDO News Radio, 105.5 FM and 1240 AM. We'll check the top headlines of the day, and we'll continue with Catherine in just a couple moments. Thanks for listening to KRDO's Extra. Our guest is Catherine Hammond, and we've got a question that we're going to ask. Was that Christopher? Christopher called in. Good question, Christopher. Apparently, thank you for calling. By the way, if you have a question for Catherine, call 473-1240. TJ, our producer, will take your question down. We'll try to get it asked and answered before we leave the air, and we'll be on till almost 10 o'clock on KRDO. Catherine, here's a question from Christopher. A good question. He's apparently got some student loan debt. And I guess you could even add more the debt in total, but his question was specifically student loan debt. If a person with a lot of student loan debt dies, does the debt follow them? What if they have an estate? How does that work? And is there any forms or papers you have to sign?
One of the nice things about debt when you die is that it doesn't get inherited by anybody else. So your debt when you die only would be payable out of anything that you leave behind that belongs to your estate. So if you own a house, they would definitely take money from your house or your bank accounts or other assets like that before your money could be distributed to whoever else. However, if you have a co-signer on your student loans or other debts, then your co-signer is still possibly responsible. And then there's some other things, other nuances to that. If you own joint property, when you die, it's now owned 100% by the other joint owner. And so technically speaking, they're probably not going to be able to collect on your debt from the new owner of your property. And similarly with life insurance, when you leave life insurance behind, if you name a beneficiary, let's say that you name your son, and he receives the life insurance, it belongs 100% to him after your death, and your creditors cannot get any of that money. So nobody else inherits your debt, but if you leave stuff behind, your stuff would first go to pay your debts.
Okay, so they're going to take your assets if you have any left.
Absolutely.
That makes total sense.
If they're still yours after your death.
Got it. So if you're married and a husband, let's say the husband dies, the wife would maybe have, she's still got if it's joint property, but maybe he had credit card debt. It was only in his name. That's where it could get sticky, correct?
That's where it gets sticky, and that's where the nuances of what assets did he leave behind? Are they now owned 100% by wife? All of those questions come into play, and it's helpful just to chat with an attorney when somebody passes away before you start paying any of those bills.
Well, I bet that's unfortunately, it's one of the first calls you need to make.
Right, absolutely.
I'm curious. I've heard the term, and I think I know what it does, but how important is an executor in the will? What do they do?
The executor, or personal representative as we call them in Colorado, is the person who you name in your will who's going to administer everything after you're gone. Okay. So the first thing that they do is, well, first of all, important to understand that all you're doing in your will is nominating somebody to be in that position. You're not actually able to appoint them. So they have to apply to the court and request an appointment as your personal representative. So there's some paperwork that they have to go through. They don't immediately have authority. They don't automatically get appointed. So once the court decides that, yes, after you filed all your paperwork, you can be appointed, then they give you permission to start doing things. And they tell you how and when to do the different things. And the things that a personal representative would do is evaluate everything that's owned after your death, figure out what all the valuations are, make sure that all of your creditors get paid, and then make the distributions of the rest of your assets either to the people that you named in your will or the people that state law has chosen for you if you didn't have a will.
That's a good question. Since you brought it up, let's go there next. If you don't have a will, what happens?
No will or dying intestate is actually the most popular type of estate plan in the United States. So 7 out of 10 Americans die without any kind of written plan in place.
7 out of 10?
That's what they say.
Whoa.
Yeah, so very common. But what happens when you don't leave behind a directing document, a will or a trust, is that Colorado state law kicks in. And so there's a priority for who would be appointed as your personal representative. And then for beneficiaries, there's also a priority. So if you have a spouse, it would default to your spouse. If you have children and no spouse, then it defaults to your children. There are some different nuances then in terms of if you have children from a different marriage and a new spouse, everybody might have a right to some portion of that. And then if you don't have children or a spouse, it goes to your parents, then to your siblings, and then it keeps going out from there.
Okay, and this is all done by the court?
Yes.
Okay. Where should one keep their original copy of their will?
That's a complicated question.
Okay.
Or a complicated answer. Where should one keep the original will? The original will is important to have when you die because the court does want the original. They don't want a copy. Okay. And so a lot of people will put it in the old-fashioned days, your lawyer would keep it, which then conveniently requires that your family go back to your lawyer and hire your lawyer to do the probate after you die. It's a great annuity plan for us attorneys if you have to come to me to probate the will, because pretty much every one of my clients is going to die at some point. So nowadays, people will often put their will into their safe deposit box. Sounds great. It's a nice, safe place, except that your safe deposit box gets sealed upon your death. And nobody can get in there until somebody's appointed. So there are some procedures where you can now get into a safe deposit box without having to be appointed as personal representative, but it gets a little bit stickier. So having a safe deposit box with a joint owner on it is one option. Putting it in a fireproof safe in your house and making sure that somebody else has the combination. The most important thing is to communicate with your family about where your documents are. Okay. Give them all of the instructions, that legacy drawer that you mentioned that Dave Ramsey was talking about. What a gift that is, along with a list of all of your assets, a list of your bank accounts, a list of your life insurance policies, even a list of your debts, so that in the tragic situation when you're the one who perishes, your family is already grieving. We can at least minimize some of the legal and practical headache and heartache.
Boy, we're going to continue in just a moment. I know, I generally pay the bills. This is just an example, but my wife said, teach me how to do this if something does happen. And so I was able to provide a document that's secure, but different websites for paying different bills. I actually listen to security experts, and they all have different passwords. Because look what just happened at Yahoo. So, those are things you got to think about when you're, it's an uncomfortable conversation, but it's certainly something you need to do. All right, we're going to continue in just a moment. If you have a question for Catherine, we have a little over 5 minutes, about 10 minutes left with her. Give us a call, 473-1240, 473-1240. We will ask that question, and we'll continue with KRDO News Radio's Extra. The time is 15 minutes before 10 o'clock. Good morning. Well, the phones are on fire, and we want to thank everyone for calling. Jim is our winner for the Captain D's gift certificate. Catherine, TJ is lining up some questions for you, so we will get those hopefully in a moment. The phone has been ringing nonstop, and we appreciate those calls. He's going to try to get those to me in a couple of moments. We will continue. One of the things that I've heard Dave Ramsey say, and you listen to his program, and it becomes obvious, and it's not every family by any means, but sometimes when money is involved, I'm sure you've seen it, where family members who you thought were getting along well maybe aren't getting along quite so well. And again, that's why everything should be directed in a will so there's no squabbling.
Amen.
Okay, so you've seen it.
Right. I have seen it, sadly, all too often. And I've had a number of clients really confidently believe that when they die, their children will get along perfectly. And sometimes those children end up fighting. And it's funny how disability and death just bring up all the issues that have been bubbling under the surface for years. I always knew she loved you more than me. They always treated you better than me. They gave you more money than me. All those little things, even from people's childhoods come out. And having clear documents is one of the things that you can do. But there are a lot of other things that we recommend in terms of conversations and planning to help prepare people. We even have a document that we provide to families who are really interested in minimizing the conflict that allows people to pre-agree that they're going to get along and accept whatever you, the parents, put in your documents and whatever plan you set out. Once they sign that document, say we are not going to fight, it doesn't prevent them legally from fighting later, but it solidifies in their mind that commitment a little bit more than if they had never made that commitment in the first place. So we work really hard to do everything possible to help people walk through this. And that's why, I think grief counseling is really important because there are a lot of issues going on for people emotionally, and we want to have something to put it on. And your surviving sibling that you had a little bit of unresolved resentment for is a great one to put it on.
Carol called in. Good question. She said she made a will 16 years ago and wants to know, and she had the original, when you do a new will, does that totally negate the will she did 16 years ago?
When you do a new will, your new will would typically say that it is completely revoking your previous will. It should say that. If it doesn't, that could be a problem. And even if it does say that, you want to completely destroy any previous wills. Courts are funny about wills. If there's a previous will out there, they get funky about, was it really revoked? Which one did they really intend to be the last one? It's much, much better to completely destroy any previous wills. And back to your point about trusts, all of this stuff related to wills really becomes most relevant if you're using a will as the foundation of your estate plan. If you're using a living trust, then we don't have to worry as much about some of these things. We don't end up having to go through a court process as long as you do it right.
So if you do a trust, you don't need a will. Am I understanding that correctly?
You do still need a will, but it's just a backup will. It's called a pour-over will that we hope not to have to use. The only reason why we would use it is, for example, if you went out and bought a new house after you set up your trust and forgot to ever put it in there, then the will would catch that new house and take it through probate and then pour it over into your trust after your death so that all the protections against your greedy son-in-law, against whoever else, whatever things you're trying to protect around, all those protections can still apply even if something had to go through probate. So we do it just in case.
Okay. So again, this is why you need an attorney. You need an attorney that knows what they're doing. Catherine, don't you have some seminars coming up from time to time?
We do. And I love January because people make New Year's resolutions, and a lot of people say, okay, this is the year that we're going to get our estate plan taken care of. So our workshops in January are some of our most popular of the year. We have 2 workshops on Wednesday, January 11th at 2 in the afternoon and 6:30 p.m., I believe at the Rock Rimmon Library, and then on Saturday, the 14th. And if you're interested in coming to one of those workshops, they're educational, no pressure. You can go to our website, coloradoestateplan.com, and look up workshops, or call our office, which is 719-520-1474.
Okay, and we appreciate your time. We appreciate your expertise. We will get you back in January again, because this is an issue that we all have to face one way or the other. And, talk about doing something good for your family, that when you do pass away, that you've got everything for your family. It's all taken care of. There's no bickering. Everybody knows where the money's going to go. Dave Ramsey also said that. I keep bringing up Dave Ramsey, but he talks about this a lot. He said, if you do a will, he said, if you've got a large family, sit the family down and say, this is how this is going to go down. Sister Betsy, she gets grandma's ring, and brother Doug gets the car, or whatever it is.
Right, and even the little stuff.
And you lay it out so then it's all clear. There's no muss, no fuss, and hopefully no fighting.
Right.
All right. Good to see you, Catherine. Why don't you give your contact information one more time?
719-520-1474, and our website is coloradoestateplan.com. Thanks so much for having me.
All right, it is our pleasure. You are on KRDO News Radio, 105.5 FM, 1240 AM. This is KRDO News Radio's Extra. Coming up in just a couple of moments, we have the troubleshooter, Tom Martino. He helps solve problems too. So if you're dealing with a business and you're having some issues with, Tom can sometime nudge them along to help you get what you need. And on the other side, Tom also likes to highlight businesses that are doing great business practices and they're taking care of their customers. It works both ways. Tom Martino, and by the way, you can call Tom. He'll give you his number here in just a little bit, and he is the troubleshooter. He's been doing radio in Colorado for years and years and years, and we are glad to have him on KRDO News Radio. The time is approaching 9:56 ABC News, and Tom Martino straight ahead on KRDO News Radio, 105.5 FM and 1240 AM.